Okay, so let's start then. So in the last class, we discussed about what is tort, some basic introductory definition of what is tort. So we discussed that tort is a wrong which is independent of contract. Okay, so tort is a wrong which is not a contract. Okay, which is not out of a contract. Okay. And then we learned that it's a civil wrong. When we say it's a civil wrong, by that we mean that it is not a criminal act. It's not a criminal wrong. Okay. And because it's a civil wrong, it gives rise to something called a civil remedy. So the plaintiff will have civil remedy in the civil court. Okay. So remedy takes what form? It takes the form of a compensation. Okay. Compensation that is to be recovered from the defendant. Okay. Now compensation of what kind? So I told you that unlike in contract where the the damages is liquidated, in case of tort the compensation the damages here is unliquidated. So how did we distinguish between this? The distinction is quite simple, that in case of tort the parties do not already determine what the exact amount of compensation will be, because there was no meeting of mind, there were no mutual promises from one party to the another. So it's up to the court to determine in the light of the fact situation as to what will be the compensation. So whereas in case of contract, what happens? The compensation is part of the contract itself. So I told you that we took up an example in the last class that okay, so I promise to deliver certain goods at certain place and at certain time, okay, within certain time, in consideration for whatever the consideration it is, could be some amount of money, and if I fail to do so in time, then the contract itself says that okay, I will then be compelled to compensate the other party for not being able to fulfill my duties. So whatever is the compensation will be part of the contractual stipulation. So for example, I say that I have to deliver 10 bales of cotton at a certain place at a certain time. If I fail to do so, then I'll have to pay that person 1,000 rupees. Okay, it's part of the contractual stipulation. So you see that in case there is a breach, okay, the damages here is already part of the contract. Okay, and that's what I have to pay for failing to do my part of the contract. Okay, so we say that this damages here in case of contract, this compensation is liquidated. But as I told you yesterday, in case of tort, okay, so someone trespasses my property, someone libels me, okay, slanders me, so someone creates some kind of nuisance by, for example, playing loud music, etc., etc. Okay, in the middle of the night, they do not already determine as to what the compensation will be in those situations. So we say that in case of tort, the damages, the compensation is unliquidated. Okay, so this is broadly what we discussed. Then we quickly looked at also what Salmond has to say about tort. He defines tort in a certain way. He's the guy who says that there are certain number of torts. Okay, there are no indefinite number of torts. Okay, so he's the one who comes up with the pigeonhole theory we discussed in the first class. Okay, so his definition is that it is a civil wrong. So far it's in accordance with what we discussed. So Salmond says that tort is a civil wrong for which the remedy is common law action. So when he says common law action, he basically says that it does not arise under court of equity. It arises under court of common law. Okay. In India, we do not have separate court of equity, so that question does not even arise. Okay. For unliquidated damages, I just explained to you what unliquidated damages are. Okay, which is not exclusively the breach of contract. So we already discussed that tort is not a breach of contract. Then he adds that it's not a breach of trust. So tort is also not a breach of trust. Trust is a separate branch of law that I will explain to you later on. Okay, or other merely equitable obligations. So in England, they have, I told you, they have a court of common law and court of equity. So tort does not arise under equity, it arises under common law. So that's essentially the definition that has been given to us by Salmond. Okay, now if we have, so I am going a little fast because this portion we have already discussed in the last class. So let's look at the other definitions that we have. So if we discuss Salmon, then we definitely have to also discuss what Winfield has to say. Okay. So how does Winfield define tort? So he says, tortuous liability, so according to Winfield, tortuous liability arises from the breach of a duty. Okay, so tortuous liability arises from what? From a breach of a duty. So there is a duty, you have breached that duty, and from that breach of that duty, tortuous liability arises. Okay, then you ask me, sir, where does that duty come from? Okay, where does that duty come from? So he has to say something about that. So he says, tortuous liability arises from a breach of a duty primarily fixed by law. Okay, so that duty is fixed by the law. Okay, so if I say that someone has a duty, that means that there is a correlative right in someone else. Okay, so if A has duty, B has a right. Okay, so B's right is infringed. Okay, that right is a creature of the law. Okay, and the duty, correlative duty on me to not breach that right is also a creature of the law. Okay, so is it clear? Is this portion clear to you? What I tried to explain to you, is that clear to you? You can either type there or you can.
Yes, sir.
Okay.
Yes, sir.
Yes, sir. Yes, sir.
Okay.
Yes, sir.
So it's.
voice was breaking.
Do not worry. Okay, if my voice is breaking, I'm recording. I'll upload it. You will get the clearer version very soon. Okay. Is that fine? Okay, because I am from a village, remote village. The connectivity is, the Geo is cheating us. Now, initially it was good connection. Now gradually it's just getting worse every other day. So let's see. Anyway, do not worry. I'll upload this lecture very soon. So yes, so Winfield says that tortuous liability arises from a breach of a duty. Okay, now that duty arises from what? That duty is primarily fixed by law. So if a duty is fixed by law, someone else has a right. Okay, so you have infringed someone's right. Okay, so tortuous liability arises from infringement of someone's right. Okay, and from breach of that duty by someone else. Okay, so then he says this duty is towards persons generally. Okay, now this duty that is being talked about is towards persons generally. Now what does he mean by that? How can I have a duty towards persons generally? So when I say that there is a duty towards, when he says that duty towards persons generally, he's saying that the right is also general. Okay, the right here, the correlative right here is right in rem. Okay, that means what? So I have a right. Okay, and the rest of the world has a duty. Okay, that's funny. You will be asking, sir, how the hell is that possible? How is it possible that the rest of the world has a duty? So let me give you an example. So if I have a property here, okay, so let me say in simpler terms, because you guys are in first year, we will not go into complications. Okay, so if I have a property, I say that I have a property right. Okay, one of the aspects of property right is that others will not infringe it. Okay, others will not trespass it, others will not enter your property without your permission, because this is your property. Okay, so you have a right that others do not enter your property without your permission. Okay, so who has the duty not to interfere with your property? Is it A, is it B, or is it all the people out there? Exactly, very correct answer. All the people. So this is what he is saying, that that this duty is towards persons generally. Okay, so whosoever has this duty generally towards a person. This is not a duty that is creation of a contract. Okay, because when we enter into a contract, that duty that comes up, okay, that is between person A and B, whereas in this case it is, for example, between person A versus the rest of the world. Okay, so that's the nature that Winfield is trying to explain to us. So he says, tortuous liability arises from the breach of a duty primarily fixed by law. This duty is towards persons generally. And then he says, and its breach is redressable by an action for unliquidated damages. So you know that the last part is quite clear. Okay, we know already. So if there is a breach of this general duty, then you can initiate an action, okay, a civil action, and the remedy that will be provided to you will be an unliquidated damage, because it's a general duty, so there possibly could not be liquidated damage here. So it's as simple as that. Okay, so is Winfield clear to you? Is Winfield and his definition here of tort understandable?
Yes, sir.
Okay, then cool.
Yes.
So it's very simple. It's a very simple paper if you just follow me. But it's also a very philosophical paper. But I think I will do injustice to you guys if I go into philosophy too early. But anyway, keep these ideas in mind. We can always relate with these ideas later on. There is two more definitions that I have, okay. One is by Pollock, but I think Pollock will get you very confused. It's a very big definition that he has created, okay. I think I will skip that, but I will share this with you guys, okay, later on. So I will look at what Underhill, the book that I had shared the other day, that fella has also to say something about tort. Okay, let's see what he says. Okay, so Underhill says a tort is an act or omission. Okay, so I discussed that other day. Okay, so there is some kind of action, isn't it? So some kind of wrong. Then that wrong could happen either because of an action on the part of someone. So for example, someone enters my property. Okay, or because of omission. So for example, someone does not take reasonable care and leading to certain accident by negligence. Okay, so that's the case of omission. Okay, so he is saying that a tort is an act or omission which is unauthorized by law. Okay, so if this act was authorized by law, then it cannot be a wrong. Okay, if this omission is authorized by the law, then it cannot be a wrong. So such act and omission has to be unauthorized by law. Okay, and independently of contract. So same thing, tort is not a contract. Then he says infringes. So this said act infringes some absolute right of another. It could be some absolute right that you have, so as against the rest of the world. Okay, and gives rise to an action for damages at the suit of the injured party. So if the injured party initiates a civil suit, then that will lead to a civil action, in which case you will be given damages. Okay, he doesn't use here the word unliquidated, but we know that it is unliquidated damages. So these are the three definitions I thought I will introduce to you guys, okay, so that you guys have a very simple understanding of what tort is. Okay,
Sir, could you please repeat the definition?
Which one? The last one?
Yes, sir.
Okay, so the last one is by Underhill. This the book that I shared the other day with you guys. Okay, so he says a tort is an act or omission. So earlier I said that a tort is a wrong. Okay, that wrong arises from what? It either arises from an act or from an omission. So when I say act, it means you do something that leads to that wrong. Okay, and when I say you omission, it means you do not do something and that leads to the wrong. Okay, so I gave you two examples. Someone enters your property without your permission. What is it? An act or omission?
Omission.
No, it's an act in the sense, why you're saying that it's an omission
It can
because
be both.
So listen.
Can be both, right?
Yeah, it can be, but let me focus on the special, the essential aspect here. Okay, so when you say that without your permission, so that's why you are saying that omission here. Okay, I understand that. Okay, but the essential part here is that someone has entered your property. So entering the property is what? An act, isn't it? Okay.
Act.
Okay, so that act leads to a wrong. Okay, that act leads to a wrong. Okay, so that's a case of an act. Omission would be where? So for example, there is a structure. Okay, it is not properly maintained. Okay, and it is supposed to be maintained properly, and it is open to people. Okay, people entering there. someone enters there and a portion of the structure falls on his head and he gets injured. Okay, so is it a case of act or an omission?
Omission.
Yes, it's a case of omission because it was a duty on the part of someone to maintain the structure, okay, and that person has failed to do so, okay, so it's a case of omission. So that's what Underhill is referring here, okay, that it could be that wrong could arise from an act or an omission, okay, which is unauthorized by law. So if the act was authorized by the law, then you have the defense that, well, it's not my fault, okay, what I have done is allowed by the law, okay, it's not something illegal that I have done, okay, the law authorizes me to do something, okay. So if the law authorized you to dig somewhere and someone just got hurt in the process, okay, then you will say that I was digging, taking all the precaution because the law allowed me, okay. But if you are just randomly digging somewhere and someone gets hurt without the authorization of the law, then that person will say that, why were you digging here? Silly example, I hope you understood, okay. So if your action is authorized, then it does not lead to tort, okay. Same goes for omission. Then he says it's independent of contract. Of course, tort is not a contract, okay, just to drum it in your head, okay. Then he says that infringes what? An absolute right. So when he says absolute right, essentially he's saying that it's a general right, okay. A general right means right that you have as against the rest of the world, okay, and the duty will also be a general duty, okay. So that's what he's referring to here. And then he says that gives rise to an action for damages at the suit of the injured party. So the injured party has to initiate a suit in the civil court, and that will lead to an action for damages, but he doesn't say unliquidated, but we know that it is an unliquidated damages. So I hope that these three very simple definition makes it crystal clear for you as to what tort is, okay. Is that clear now?
Yes, sir.
Okay.
Yes, sir.
Now here's a word of caution, okay. So when I introduce the topic to you, it's very simple, but as you go into detail, you will see that there are many confusing parts, okay, here and there. So even in contract, for example, some damages, some compensation could be unliquidated. Maybe if it is not determined by the parties already, then the court has to exercise discretion there, okay, as to what compensation, what damages have to be provided, okay. So you will see that in many cases there will be overlap. The same set of facts, okay, the same set of facts can lead to both a case of tort as well as a case of contract. So those problems will arise, okay. But at the theoretical level, we are now crystal clear as to what is a tort and what is a contract and how they are different. Now we'll make certain other differences in the course of time, okay. So let's now proceed to the next important topic, okay. So the definition is clear. Let's now look at certain other branches of law, okay, which are not tort, okay. Those are civil as well as criminal, okay. So let's start with, okay, as I just told you, let's start with distinguishing between a tort on the one hand and a contract on the other, okay. All these definitions say that a tort is not a contract, so something has to be about it, okay. So something has to be important about it. So how is that, okay. So what is that? So I told you that a contractual relation, okay, a contractual relation, a contractual obligation arises based on consent, okay, based on consent. So what do I mean by consent? So you will to, you choose to, you will to enter into a contractual relationship. So there is an element of consent, okay. No one forces you to be in a contractual relationship. So consent is a very important aspect of it. So I told you other day that contract is based on this principle that promises ought to be kept, okay. But that promise that I'm talking about has to be voluntary. It cannot be coerced, okay. If it is coerced, then it is not a, it's not a it's a, I mean, what do you call it? It's a voidable concept, contract, okay. You will study that later on. Now, consent is very important in case of contract. So no fraud, no undue influence, misrepresentation, etc. can be used to make someone to give consent. Okay, so consent is a very important aspect of the law of contract. Whereas in case of tort, the question of consent does not even arise. Okay, no one consents to be harmed. No one consents to be harmed. So the principle in case of tort, if you remember the other day, is that you shall not harm someone. Okay, thou shalt not harm thy neighbor. Okay, the entire law of tort is essentially based on this principle. Now, no one consents to being harmed. Okay, so you understand that consent is not an aspect of the law of tort, whereas in case of contract, it is clearly a case of consent. Okay, so that's the first distinction that we make between tort and contract. The second important aspect is privity, element of privity. Okay, let me type it out for you. If you can see in the chat box, okay, you see I have typed the word. Okay, it's called privity of contract. What does that mean? It essentially means that in case of contract, the relation arises only between the two parties. Party A enters into a contract with party B. All the legal matters that arise, okay, with respect to the contract are confined, restricted to these two different parties. There are certain exceptions, I'm not going into that, but general rule is that it is restricted to those two parties only. So that's the idea of privity of contract. Okay. But as I told you, in case of tort, the question of privity does not arise, because anyone can commit a civil wrong as against you. Okay, so since anyone can do it, so the question of privity does not even arise. Okay. Yes, is it clear? Is this are these two differences clear to you? I hope I'm not moving too fast.
Yes, sir.
Okay. Okay. So very simple. Okay. 2 points we have discussed. Those are in simple words. Contract is based on consent. Tort is not based on consent. Okay. There is something called privity in contract. Privity does not really exist in case of tort. Okay. But for the sake of confusion later on, okay, there are some torts that could be kind of based on consent. Okay. So for example, Occupiers Liability Act, okay, it creates a liability on the occupier of a particular property, that he or she maintains the property in a certain condition, so that if someone enters the property with permission, okay, does not get injured. Okay, now this someone who enters your property has to enter the property with your permission. Of course, that's given, isn't it? What does that mean? Okay, that person has consented to enter your property. So in such case, if that person gets hurt, it seems like, okay, the relation here has started because of the consent. Okay, but the case is kind of like of a tort, isn't it? Okay, so these are the situations when it becomes difficult for us to say whether tort is purely based on purely not based on consent. But in this situation we see that this is kind of a tort which is based on consent. But then remember, you merely consented to enter. Okay, from that act itself you do not say that I'll be subjecting myself to be harmed. Okay, you do not say that. So a kind of distinction can still be made. Okay, so I will not get you guys any more confused than this for now. We will discuss this in greater detail later on. But the broad distinction is that contract is based on consent, tort is not. Okay, so I hope that is clear. And there is privity in contract. There is no idea of privity in case of tort. Now, yes, there is something called breach of contract. Okay, so as you know, contract is what? Contract.
So what of contract?
I'll type it. Can you see it? It's breach of contract.
Yes, sir.
Okay. It's essentially, it means breaking the contract, okay. In simpler words, okay. So what do we have in contract? So in case of contract, what you have is that there are certain mutual promises made by A to B, okay. Both those promises, acting as a consideration for each other, okay. And then that agreement is legally valid. If it is legally valid, then it is a contract, okay. As simple as that. I'm simplifying the definition, okay. Now what happens is that so both the parties make promises, but it is possible that the parties also do not fulfill their part of the promise, okay. So if they do not fulfill their part of the promise, that's what we call breach of contract. Is it clear? In silliest, simplest possible explanation, that's what we call breach of contract, okay. Now what happens is that how do we distinguish breach of contract from that of a wrong, a civil wrong that we call as tort, okay. So how do we distinguish between this? Okay, so here's the difference, okay. When there is a tort, okay, when there is a tort, okay, a civil wrong, as we discussed earlier, there is a violation of right in rem. I told you guys, I explained to you guys this concept a little while ago, okay. In case of tort, in case someone commits a tort, he or she violates a right in rem, okay. Right in rem means right as against the rest of the world, okay, right as against the rest of the world. So if you have a property, the rest of the world has a duty not to enter your property without your permission. So you have a right that the rest of the world does not enter your property without your permission. So this right that you have as against the rest of the world is known as right in rem. So in case of tort, the right that is violated is a right in rem, okay. Now, as you know, in case of contract...
So can you type it right in?
Yes, I'll type it.
Yes.
Is it visible?
Yes, sir.
Okay.
So in case of torts, it
yes,
is right in rem, and what is the case for contracts?
Yes, I'm coming to that. So in case of tort, the right that is violated is a right in rem. Whereas in case of contract, the right that is violated is a right in personam. I'll type that as well. Do you guys see it?
Yes, sir.
Okay. So the right that is violated in case of tort is the first one, right in rem. The right that is violated in the case of a contract, okay, breach of contract, is a right in personam. Now what does right in personam mean? Okay, as I told you, these rights are kind of personal rights. By personal rights, I'm not talking about I'm not distinguishing between property and person, okay. I'm not doing that. All I'm saying here is that of course it is a proprietary right because contract is with respect to property, okay. Now what do I mean by right in personam? By that I mean that so A promises to do something in respect of B in consideration for B paying a certain amount of money, okay. The obligation arises between two specific persons, doesn't it? Do you guys understand? The obligation, the legal relation here in case of contract is between two specific persons, person A and person B, okay. That's why the right that one person has as against the other person is a right in personam, because that right is not as against the rest of the world. A has a right as against B. So do you understand? Is that clear?
Yes, sir.
Okay. So in contract, the right, in breach of contract, the right that is violated is a right in personam. Whereas in case of tort...
Can you repeat once more?
Yes, tell me. You want me to repeat it?
Can you repeat it once?
Yes, so for example, I'll give an example of right in personam. So for example, I promised you to deliver certain bags of rice by next Sunday, okay, 10 a.m. in the morning, okay. in consideration for you paying me rupees 1,000. Okay, so suppose a simple contract between me and you. Okay, now I fail to deliver 10 bags of rice to you by 10 a.m. By the next Sunday. Okay, so that right I have just breached. Who has that right? You have that right. Does the rest of the world have that right? No, it's only you who has that right. And who do I have the duty towards? Do I have the duty towards the rest of the world? No, I only have the duty towards you. Okay, so this right here that you have as against me is a right in personam. The duty that I have as towards you is a duty in personam. So is that clear now?
Yes, understood.
Okay,
Yes, sir.
so that's the kind of right that you have in case of a contract, whereas in case of the tort, the right is in rem, because the rest of the world has a duty not to infringe, and you have a right as against the rest of the world that your right is not infringed. Okay, so yes, that's another distinction. That's the distinction that we make between a tort, okay, and a breach of contract. Okay. Another important factor that will help us in distinguishing between tort and breach of contract is the importance of motive. Okay. Now this is problematic in the sense that in some torts, motive is important. In some others, motive is not important. So you enter into you trespass into someone's property. The question of motive does not even arise. Okay, that you did it with good motive or bad motive does not even arise. Okay, but in certain other torts, it is important that it is not important that motive. So in some torts, it is not important that motive is there. In certain others, it is important that motives there. We will discuss that in greater detail later on. Now, in case of contract, it does not really matter. Okay, if there is non-fulfillment of the terms of the agreement, okay, then there is a breach of contract. So it does not. The question of motive does not even arise in case of breach of contract. The third important. Yes, tell me.
Yeah, sir. So you're saying motive as synonymous to intention, or you differentiate motive and intention as different? Because in some court we have intention.
Yeah, I'll differentiate. I'll come to that specific aspect later on. I'm just using the word motive in the whether you had a good motive, bad motive, whatever. Okay, so I'm kind of using it interchangeably. Okay, so for example, you entered into someone's property. Okay. Does it really matter whether you entered with whatever motive it is? No, as long as you have entered the property, okay, without that person's permission, you have committed trespass. Okay, so it does not really the motive is not really that important. Whereas in many others, okay, the motive could very much be important. But in case of contract, what do we have? Okay.
So I have a question.
Yes, Samriddhi, tell me.
Sir, suppose there is a condition that someone trespasses someone's land to save a person or save himself.
Oh, exceptions are there. There are certain exceptions. Okay, there are certain exceptions. So it could be that. Okay, so let me give you an example. Okay, you are in a life-threatening position. Okay, someone is trying to kill you, and you have no other way but to enter into someone's property. In that case, will the law be blind to your situation? It will not be. So there are defenses, okay, that we will discuss later on. So for now, I'm just basic introduction. Okay, so all those things are there. Okay, so for example, even in criminal law, you will have certain defenses, okay, related to offense, related to property, etc. So if the neighboring house catches property, okay, then and there are other houses in between your houses there, then in order to stop the spread of fire, a portion of your house could also be damaged. Okay, so that this fire does not like spread everywhere. Okay, so I'll come to defenses later on. For now, what I'm telling you is that just think of it. Okay, But I think this distinction is not really that clear, in the sense that in certain others your motive is, in some motive is important, in certain others motive is not important. But in case of contract, does it really matter? Okay. But in contract, what happens is that you do not fulfill the terms and conditions of the contract, then there is a breach of contract. We just know that, that's it, that's the definition. So the third important distinction that we make is imprecision of measure of damages. Now this is something that we have already discussed. Okay, so we discussed that in case of tort, the damages is unliquidated, whereas in case of contract, it is liquidated. Okay, so that is there. But even in contract, okay, even if it is the damages which is to be paid in case of breach is already not stipulated in the contract, it is still possible for the judge, from the circumstances, from the stipulations, to come to a kind of conclusion about what measure of damages is to be provided. Whereas in case of tort, it's much different. Okay, and when I talk about precision might not even a criteria in case of tort, in the sense, as I told you, if the damages, okay, if the compensation which is to be paid is not merely compensatory but also deterrent or punitive, then precision does not really matter. Okay, so yes, that's another difference that we make between tort and breach of contract. And then lastly, another point that I need to tell you guys is that the same act may lead to both a tort as well as breach of contract. Now, for example, you are being operated by a surgeon. Okay, you are being operated by a surgeon. Okay, now you are in a contractual relation with the surgeon. That surgeon will exercise due diligence, reasonable care while operating you. Okay, now what the surgeon does is leaves a scalpel or something inside your body, and then sutures you. Okay, then what is it? Is it a case of tort or a case of contract? Breach of contract. Which one is it?
It can be both.
Yes, exactly. So the same set of facts could lead to both. Okay, so it is a breach of contract. Why? Because there is a contract between you two parties, that other party will fulfill his part of the whatever is the agreement here properly. Okay, and that person has clearly failed in doing that. It's res ipsa loquitur. It speaks for itself that there is a scalpel in your body. Okay, and then you also have a right, a general right, as laid down by the law itself, that the other person exercises reasonable care towards you. Now that reasonable care has also not been taken, leading to a infringement of a general right that you have as against that other person. Okay, so it's also a case of tort. So the same fact could lead to both a tort as well as the contract. Okay, but what compensation you will be paid, that will be for the judge to determine in the instant case. But you will not be paid two separate constant, one for the breach of contract and one for the tort. No, you will be paid one compensation. Okay, and it's for the judge to determine that. Okay, so is that clear here? Is this example clear?
Yes, sir.
So there is a case, okay, that I will refer to, and with that we will end our discussion for today. I will type it here. Okay. Okay, so the case is Rajkot Municipal Corporation versus Manjul Ben, Jayantilal, Nakum and others. Okay, so in this case, I'll just quote it. Okay, the ratio here, it says, in tort, the duty is towards the persons generally, while in contract, it is towards specific persons or person or persons. If the claim depends...
So can you repeat, please?
In tort, the duty is towards the persons generally, while in contract, The duty is towards specific person. Okay. Now, if the claim is dependent, okay, if the claim depends upon, could you please turn off your mic, Ankita? Okay.
Yes, sir.
Okay. Okay. So then it is said in in that judgment that if the claim depends upon proof of contract, action does not lie in tort. So if the claim that you have made in the court depends on proof of contract, then the action cannot lie in tort, because you are talking about some specific stipulation between two of you. Okay, so that's the duty in personam or right in personam. So obviously the claim will not lie in tort. Then it further says, if the claim arises from the relationship between the parties, okay, independent of contract. Okay, if the claim arises, okay, from the relationship between the parties independent of contract, an action would lie in tort, okay, at the election of the plaintiff. So it will be clear from the suit that you have instituted as to what kind of claim that you have made. If you are referring to the contractual stipulation, then obviously what you get is based on the contract. But if it is not based on those stipulations but a general right that you have, then obviously it is a case of tort. Then it further says that the law.
Can you please repeat the line, if the claim arises from the
Yes,
relation
yes,
between...
yes, I will do that.
Yes, sir.
If the claim arises from the relationship between the parties, okay, from the relationship between the parties, that means there were promises. Sorry, it's not promises. Okay, he says if the claim arises from the relationship between the parties independent of contract, that means it's not based on the promises. Okay, an action would lie in tort at the election of the plaintiff. Okay, although they might.
Action will lie what?
Action would lie in tort at the election of the plaintiff. Is that clear? I will just type it there. Okay, I think because of the network. Do you see? An action would lie in tort at the election of the plaintiff. So from the suit we can assume what kind of suit it is. Okay, whether it's based on the contract or whether it is based on a general right that you have. Then it further says, although there might alternatively have pleaded in contract, so it could have been possible for you to even plead in contract. So if you had pleaded in contract, then the right that you refer to would be based on the stipulations between you and the sergeant, for example, here in concern. Okay, is that clear? But if it is not based on those stipulations, then the court will assume that it's a general right that you are pleading here. So that's what it says. Then the judgment further says, the law of tort prevents hurting one another. Okay, all torts consist of violation of a right in the plaintiff. Tort law therefore is primarily evolved to compensate the injured party by compelling the wrongdoer to pay damages done. Okay, I would rather type the whole thing there so that you do not miss it. Okay, the whole thing will be put there. So do you guys see it now? The entire quotation is here. Do you guys see it?
Yes, sir.
Okay, so now I hope it is clear. So it further says, the law of tort prevents hurting one another. Okay, all torts consist of violation of a right in the plaintiff. Tort law therefore is primarily evolved to compensate the injured by compelling the wrongdoer to pay for the damages done. Okay, since distributive losses are okay, you can ignore the rest, it will get you confused. All that it says is that we have a general duty to not harm one another. Tort is a violation of that general duty that you have. Okay, and that duty is laid down by the law itself. Okay, so that's it. Okay, so that's the distinction that we make between tort on the one hand, contract on the other. So that duty that arises in case of contract is not a general duty because it's not already there. Okay, yes, Kaushik, what's the confusion? Kaushik, any confusion? Okay, so I hope you can see this. Okay, you can copy and paste on your computer. Okay, so essentially what is said here is that the same fact might lead to both tort as well as contract. Okay, so it is a contract. Okay, it is based on a breach of contract if your claim here is based on non-fulfillment of a promise, okay, which is between you and the other party. But if it is violation of a general duty, okay, that you have, that the other party has of not harming you, then it is a case of tort. And from the suit itself, okay, it can be identified as to what kind of claim that you have made. Okay, so whatever you have pleaded, that will itself tell the court what kind of claims that you have made. Okay, so that's it. That's the distinction between tort on the one hand and breach of contract on the other. In the next class, we will distinguish between tort and quasi-contract, tort and crime, and tort and equity. So that will be the discussion topic for the next class.
I have a doubt.
Yes, tell me.
Am I audible?